So beginning um, at page 262, perfecting the charge, in other words, properly um, naming the accused and the charge um, in an indictment, how is that done? And on what basis can a defendant object if it is done improperly? So the indictment must generally name the accused, describe the offense, uh, identify the county, city, or town where it was um, committed, and recite um, that the offense was committed on or about a certain date. Although we'll find out that the time is not an essential element. But you've got to identify the accused, um, name them properly, minor misspellings or um, something like that, a misspelling would, or leaving out a middle name or not putting junior or whatever, um, won't be fatal to an indictment. Those can be amended fairly liberally by the prosecution. Um, Next, they must describe the offense charged. And what happens here is the prosecutor simply tracks the language of the statute. And so you will see an indictment that says that somebody knowingly or intentionally or recklessly did something or another and will state the elements of the offense. And that language is always deemed sufficient if it tracks the statute, which defines the offense, contains the elements of the offense. And these indictments, they're not working from scratch. They have form indictments that either the Attorney General's office or the Office of Prosecution Services, some entity like that, the Alabama Law Institute, or somebody has done these form indictments. The next item that is essential is that the place of the offense be named, and if that's Morgan County, state of Alabama, some other county, state of Alabama, um, so be it. Now, there may need to be further specificity if the place of the crime is important. Um, for instance, if you're charged with illegal possession of prohibited liquor, obviously, if that happened to be a felony, um, it's a bad example, but in other words, it matters where you are. If you're in a wet municipality, it's not a crime. If you're in a dry part of the county, then that has to be alleged. Something like that, if the place is critical. Otherwise, you just merely have to alert the defendant that the offense was committed in a particular county, parish, district, whatever, um, in order that the person will be able to vindicate their right to be charged in a proper jurisdiction and venue. All right. That proof is essential in a criminal case, which is always why you hear a question that seems very basic, maybe almost dumb um, sounding at least, is did all this happen in Morgan County or Madison County or whatever? They have to prove that venue is correct. All right, the next thing is the time of the offense. It's important that if the time of the offense is critical to the offense, it has to be named. Like, um, for instance, a person who's attained the age of majority, a victim, there has to be an allegation that during not the age of majority, but the age of consenting to sexual contact, if you're going to charge someone with um, illegal sexual contact with them due to age, statutory rape, for instance, then their age would have to be alleged, and of course you would be then apprised that it was within a particular or before a particular date. Sometimes there could be a statute of limitations, but I have found that the time itself is not essential to a valid indictment unless it is unclear from discovery when something is alleged to have happened. There are still offenses that have statutes of limitation, and you have to either in the text of the indictment or through the process of discovery have to be able to ascertain when something happened. And we'll talk about how that might be remedied in this when we discuss the bill of particulars. All right, so the next issue is that a charge cannot be duplicitous, which means that an indictment may contain several counts. It may contain, murder in the course of robbery, hence capital murder. It may charge felony murder. It may charge robbery. But those can't be charged in one count. They have to be in distinct counts. So a count in an indictment can only allege one crime. However, this issue of joinder allows that separate offenses that arise from a single course of conduct, a single course of criminal conduct, can be charged in the same indictment. So you can join offenses like capital murder, regular murder, and the predicate that makes the capital murder capital, whether that be arson, robbery, or something like that, burglary. And so also you can charge in the alternative, you can charge murder as count 1, manslaughter as count 2, and criminally negligent homicide as count 3, for instance. And you can only be convicted, you can be acquitted on all of those or convicted of only one. But, if the prosecutor is allowed to charge in the alternative, such that if the proof is that there wasn't an intentional killing, instead it was reckless, then the manslaughter charge is there. Or if you can prove neither intent nor recklessness, then you can also find the person guilty of the criminally negligent homicide. That's charging in the alternative. Okay, so if there is some variance in the evidence, that is somehow the evidence at trial or as it develops before trial differs from what is charged, the prosecutor can move the court to allow an amendment of the indictment. And if it is a minor issue, then it can be changed rather liberally, but an amendment cannot change the nature and character of the offense charged. So the defense can object to an amendment, in which case the court, in limited circumstances, can override that objection. But if there's a valid objection of undue surprise or something like that that would merit additional time to prepare a defense, the court can deny the amendment, dismiss the indictment with leave to re-indict. And if hold on one second. So an objection to a defective indictment would typically have to be made before the trial begins. Um, so even after the trial has begun, um, there is the ability to dismiss and reindict um, with court approval. Um, and so oftentimes um, the defense will object in order to gain more time to prepare or just more time, period, because criminal cases are generally thought to not improve with age. Memories fade, witnesses die, people move away, people decide not to cooperate, and so on. All right, the next issue is this issue of bill of particulars, and it is a motion that you can file in the civil side of the law. It's called a motion for more definite statement. And that's really what this is. A bill of particulars is an old-fashioned way of asking for more specific detail. You'll see here a sample of a motion for bill of particulars on page 266. Now, what these can be granted by the court if a defendant is really disadvantaged in being able to prepare their defense. However, often the details of the offense, like for instance the timing of it, the place and time, all of that is made clear in discovery, but oftentimes not. So sometimes there's a defendant's entitled to clear up some details about time, date, and place if those are essential to developing your defense. And in particular, a lot of times, sex crimes. Let's say that someone is alleged to have abused a child who can't provide details in a statement, for instance, that you might get in discovery. If the prosecutor knows, then you can move the court to require the prosecutor to amend the indictment such that you're defending against something that happened within a reasonable time specification, because that may be very critical to developing your defense. I mean, what if you were verifiably out of the jurisdiction and the evidence may be vague as to exactly when? If that kind of detail can be provided, and if that's essential to establishing to forming your defense, then you ask the court to require the prosecutor to amend that. One thing that is when you have what's called a, quote, resident abuser, that is, a person who lives with the child is the abuser, then those requests for specific dates, times, and places are generally not granted because typically the allegation is that something happens so frequently that the child couldn't narrow down date, time, and place, and it really makes defending those cases very, very challenging. But that's oftentimes what happens with a bill of particulars. Okay, so that's the end of chapter 13, and we'll move on to chapter 14. I'll do that in a separate video.